is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is Tracy Coates. I am the principal with the law firm of Paley Rothman in Bethesda, Maryland, where I primarily practice family law. The legalization of recreational and medical marijuana use in this country is on the rise. To date, 9 states, including the District of Columbia, have legalized the recreational use of marijuana in this country, while 29 states, including Maryland and the District of Columbia, have legalized the medical use of marijuana. However, what does legalization of medical marijuana mean for parties involved in a family law or custody matter? If a parent is legally able to use marijuana, does that have an adverse effect on his or her custody matter? Today we will discuss what it actually means for marijuana to be decriminalized, legalized. How has Maryland, as well as other states, looked to these laws concerning the recreational and/or medicinal use of marijuana, and what impact, if any, it has on a parent's access time with their children? I'm joined tonight by 2 phenomenal attorneys who will share their experience and expertise in this area. Joseph Caleb is a named partner at the law firm of Brynwald, Caleb & Robertson. Joe is a former Washington, D.C. public defender and now is in private practice, where he focuses primarily in the areas of criminal defense, personal injury, and medical contracts in Maryland and the District of Columbia. Joe attended law school at American University, Washington College of Law. Joe has extensive trial experience with serious felony crimes, including murder and drug charges. Joe is also an adjunct professor at the University of Washington Adventist School, where he has been a guest lecturer at American University Washington College of Law. Joe is also a member of the American College of Trial Lawyers as well. Emily Gelman is an associate with Offutt Kerman, where she practices in the area of family law. Emily graduated cum laude from the University of Maryland School of Law. As a trained mediator and collaborative divorce practitioner, Emily handles family law matters including divorce, custody, pre- and post-nuptial agreements for traditional and non-traditional families, and is the author of Drink a Pint, Smoke a Joint: The Importance of Distinguishing Between Substance Use and Substance Abuse in Custody Cases, which was the inspiration for the topic of today's show. Emily is actively involved in numerous committees with the Bar Association of Montgomery County, where she is the chair of the Family Law Section. She is also involved in the Women's Bar Association and the Maryland State Bar Association. So, there has been a lot of discussion about the legalization and decriminalization of cannabis use in this country. So Joe, I want to start with you to sort of give us a foundation and an understanding of what exactly that means. What does it mean for it to be decriminalized, and what does it mean for it to be legalized?
Okay. So I'll start with the first sort of term you threw out there, decriminalization of marijuana. To decriminalize means to make something not criminal, to not face criminal sanctions or punishment for the commission of a certain act. So, in other words, to decriminalize the use of or the possession of marijuana actually would mean to make it a non-criminal offense to possess a certain amount of marijuana. For example, in the District of Columbia, in the district, marijuana under a certain amount is legal. On the other hand, in Maryland, the possession of a certain amount of marijuana, 10 grams, is decriminalized. So if one were to have 10 grams or less of marijuana in Maryland, they would not face criminal punishment. On the other hand, they would face a civil punishment, and you can just compare that to a fine or, say, a penalty for jaywalking. So that would be the equivalent of the punishment, the sum total of the punishment that you could face if you were found with 10 grams or less of marijuana. So 10 grams or less would be decriminalized, versus if you had more than 10 grams, that would be a criminal offense and you could face a criminal penalty.
Okay. Is that the same also in the District of Columbia as well?
No, in D.C., in the District of Columbia, the possession of a certain amount of marijuana is actually legal, right? So marijuana is legal in the District of Columbia, and that amount is 2 ounces. So if you possess 2 ounces or less of marijuana, it is not a crime at all. It's not decriminalized. So in other words, if you compare that with Maryland, you wouldn't even face a fine or get a ticket if you were found to be in possession of 2 ounces or less of marijuana in the District of Columbia.
So it's decriminalized now in Maryland. So is that similar to if you were in possession of an amount that was outside of what the law regulates? Does that mean it's a misdemeanor in Maryland, or?
Sure. So in Maryland, if you possess over 10 grams, that is now a criminal offense, right? So the possession of marijuana is only decriminalized under a certain amount, for the possession of under a certain amount of the drug. Any amount over the 10 grams would be a criminal offense, and that would be a misdemeanor, to answer your question.
Okay. And so also other terms that are used are recreational use of marijuana and the medicinal use of marijuana. Can you sort of discuss what the difference is and how it's defined?
Okay. So I'll start with medicinal. So for medicinal, it's, as the name implies, it's marijuana used for medical purposes. So this would be marijuana that would be used or I would say given, prescribed at the recommendation of a physician or some sort of medical professional to treat or address symptoms associated with some sort of health concern. So that would be medical marijuana or marijuana possession for medicinal use. Now, medicinal marijuana would be marijuana that you would secure from a dispensary, right? And the purpose of the dispensary is, I guess, to regulate the distribution or the flow of marijuana.
Can you talk a little bit about what exactly a dispensary is? I mean, is it similar to a doctor's office? Is it a store for marijuana? Exactly what is a dispensary for people who are unfamiliar with that term?
So first of all, at a dispensary, my understanding is that there would not be a doctor there at all. A dispensary is just a place where if you had a medical marijuana card, you would be able to pick up or purchase legal amounts of marijuana. That's a dispensary. So, and I think to circle back and answer your question about medicinal versus recreational use, and so I discussed the medicinal piece, but the recreational would be marijuana that is not specifically being ingested or used to address a specific medical concern. This would just be marijuana smoking or cannabis smoking, or just to, for recreational use, to get high, so to speak.
And the recreational use, that follows the same limits in terms of possession of quantity, correct?
So in Maryland, when I discussed the possession of 10 grams or less of marijuana, that would be for recreational use. That is not the medicinal. The medicinal piece is not addressed by the 10 grams or less. There's a totally different set of regulations that govern the possession of marijuana for medicinal use in Maryland. Right. In the District of Columbia, though, recreationally or for any purpose, you can have 2 ounces or less of marijuana, whether it be recreational or medicinal.
Right. And without getting into the specifics in terms of how one goes about purchasing at a dispensary in Maryland and or the District of Columbia,
Sure.
what does a person need to do? Do they go online and they find a dispensary and just walk in? Do they need to see a physician someplace outside of the dispensary? How does that work?
Well, to legally obtain medicinal marijuana, you would need to have some involvement with a physician. And I think it's different in the district versus Maryland. But in Maryland, in DC, I believe, in the district, I believe, you definitely need to see a physician. A physician would then okay your obtaining a medical marijuana card. And I believe the same generally is true for Maryland, although the process may be different.
Okay. So we have sort of a background of what it means to be decriminalized and legalized in medicinal use versus recreational use. And so what I want to talk with you about, Emily, is sort of what it means as far as custody matters and what is the standard that we're looking at in terms of applying these laws when they're inside of a family law case.
So this is an issue that we're seeing more and more in family law cases. Maryland has a very high rate of family law cases on the court docket, so we have a lot of divorce and custody matters that come before the court. When the court looks at custody, the overarching standard for the entire state and for the District of Columbia is the best interest of the child, and that is the prevailing standard that the court is always going to look at. In a lot more cases now, we're seeing one parent or the other claim that the mom or dad is using or abusing cannabis, either recreationally or medicinally. And that's something that we used to see a lot more of with alcohol use. They would say, mom comes home every night and has 2 glasses of wine, or dad drinks, 2 glasses of bourbon a night, and that's a problem. And now we're seeing people say, well, he or she smokes marijuana or smokes cannabis recreationally, or they have a medical card. And the distinction in terms of decriminalization and legalization is not as important in the custody realm. But what is important, I think, is whether or not you're taking it recreationally or pursuant to a medical marijuana card. So in both the District of Columbia and in the state of Maryland, you can obtain a medical marijuana card and then legally buy cannabis from a dispensary. The courts have not directly addressed whether or not cannabis use should impact your custody rights or your access to your children. There has been cases across the country that have talked about whether or not you are using or whether or not you are abusing. And that's a really fine distinction that people need to understand, especially now that it's legal for certain uses. I don't think that parties need to be as scared of losing custody rights or losing access to their kids if they are a cannabis user. I think that there is still some prejudice on the bench towards maybe marijuana is not a great thing to be using, but the courts really need to look at it, and you need to be prepared to make an argument that it doesn't affect your parental judgment. So maybe you used during the marriage and that was fine with your spouse at that time. All of a sudden it becomes a problem once the parties have separated, and it becomes a weapon that someone wants to use in their arsenal when they're trying to reduce the other side's time with the kids. When that happens, it's important to know whether or not you're using it recreationally or whether or not you're using it medicinally. If you are using it pursuant to a medical marijuana card, I think you have a much stronger argument to say to the court and to say to the judge, this is as legitimate as any other prescription that I might have. And we as family law practitioners, we see a lot of cases with people who have prescriptions for Xanax, Lexapro, other antidepressants, anti-anxiety medications, pain relievers, opioids that are used for chronic pain relief. And the court, I think, is going to have to move in a direction of viewing cannabis and cannabis use through that same lens when there's a medical marijuana card involved. When you use it recreationally, that's when it really needs to be argued to the court as the same thing as alcohol use. Someone can be a parent and responsibly drink. You can responsibly watch your children and have a glass of wine, have a beer. I can't think of a lawyer or judge in the country who would disagree with that. And the same corollary needs to be drawn for the recreational use of marijuana. And there is some precedent in this state, in the state of Maryland, that the court needs to do a use versus abuse analysis. And so it's really important for people to understand that and not to go into these cases thinking that because they are a user or have used cannabis either medicinally or recreationally, that that's going to sink their custody case. And that's really important for people to understand.
And so why do you think necessarily that the two are similarly related in terms of the use of marijuana and the use of alcohol? Is it in just the way that it's used? If it's used responsibly, both users in both situations can function still? Is that what the corollary is in terms of alcohol and marijuana use?
Well, I think that the effects that they have on people, I don't think a lot of people would argue with the fact that it can impair your judgment. You're not permitted to drive after you've been drinking. Similarly, you're not permitted to drive after you have been ingesting cannabis in any form. Those are all considered, driving under the influence of a substance. And it all goes to parental judgment. When we're talking about custody cases and what is in the best interest of a child, there has to be a nexus. There has to be a connection between what the parent is doing and their parenting abilities. So if you are a cannabis user and you are only using cannabis, for example, when the children are with the other parent, that really doesn't have any effect on your parenting abilities, and it doesn't have any effect on the children's best interest. Now, if you are getting so high you can't see straight when the kids are with you, that's going to be a different analysis for the court. Just like I think if you come home at the end of the day, you have a glass of red wine with dinner, you can still observe your children, you can still parent them, you can still put them to sleep and be responsible, as opposed to coming home pounding 12 shots of tequila. That's going to be a different analysis for the court as well.
Right. And I think, would you agree that there's been sort of a renaissance in the thinking of what a user of marijuana was in the past, in terms of somebody sitting, on a curb smoking joint, versus what necessarily is more widely used in terms of how people use marijuana these days, and what those two individuals look like?
Absolutely. I think renaissance is a great word for it in terms of the public's thinking about medical marijuana and recreational marijuana use. And if you look at the trends, the majority of the country is now in favor of legalizing marijuana. That's a huge change from, say, the 1980s, when it was the gateway drug. And I do think that it used to be this sort of ideal that someone was smoking dope, ripping bongs, or smoking joints, and they didn't have a job and they were sitting on the side of the road. And now I think it's actually very, very common. I see it a lot with professionals. I see it a lot in the finance industry. And I see it a lot with lawyers as well, people who use marijuana or cannabis for anxiety, for depression, chronic pain, and those people who also just use it recreationally, who find that it is they react better to it than they do to drinking. And so I do think that as it becomes more common, and I don't know if it's becoming more common or if people are simply more open about the use now because it is so much less taboo, but the idea of who is a cannabis user is really changing.
And then how do you find that people are using marijuana in terms of not just the joint, not just the bong? How can you purchase marijuana, both either for medicinal purposes or recreational purposes? Are there a variation?
So in the state of Maryland, you can only legally purchase it medicinally if you have a medical marijuana card from the dispensaries. And the dispensaries, and they really are marijuana stores, have cannabis available in all different forms. So where people might think that you can only smoke marijuana or do a bong hit, I hear that a lot in court, the dispensaries have a lot of different options. So it's not actually as common now to hear about people smoking joints or having a bong or a bowl or anything like that, because the dispensaries have options. Edibles are options. I have a case right now where somebody has gummies, like gummy bears, that have cannabis in them. There are vaporizers are becoming very popular, both for cannabis use and actually for like e-cigarettes. The vaporizers are very popular now because there's nothing burning. So that's becoming more common. There are oil tinctures, which is literally an oil droplet that you put underneath your tongue that has a similar effect to smoking. There's also topical uses for cannabis. There are lotions and creams for joint pain that have cannabis in them that have no psychoactive effects that can be purchased at these dispensaries. And I know some elderly people who use them who've had hip replacements or knee replacements and use those cannabis oils and lotions to ease their pain. So there's a lot of educating that needs to be done, I think, of the judiciary on the options out there and what people are using this for. Everyone thinks if you're using cannabis, you're getting high. Not everything has a psychoactive component to it. There is also THC pills can be prescribed by doctors to stimulate someone's appetite. Also doesn't necessarily have a psychoactive property to it. And so that misunderstanding needs to be evolving as the use is evolving.
And what do you think, Emily, judges are looking for in terms overall, whether it's alcohol, whether it's marijuana? What do you think what factors is a judge looking for when they're trying to figure out what's in the best interest of a child, if in fact there is substance use?
Sure. I think candor is very important, getting out ahead of these type of allegations, because like I said, something that your spouse had no problem with during the marriage is suddenly an issue once you've split up. Being candid about it, being honest about the use, how you're using it, how often you're using it, the more educated you are about why you use is really important. Doctors now ask pro forma, do you smoke cigarettes, do you smoke marijuana? Showing that you've been honest with your doctor about it can be very helpful. If there was use during the marriage, anything that shows that the spouse was okay with it during the marriage can also go a long way, because that's the best person to determine whether or not your parenting judgment was impaired, was your co-parent.
And do you think that it matters, and maybe you spoke to this a little while ago, but do you think it matters where the use was, in terms of if a person's using marijuana while they actually have custodial care, even if they're out of sight of the particular of their children, versus if they are using it and the children are aware that their mom or dad is using it? Do you think that makes a difference at all?
I think it can, and I think context is key. In every family law case, you'll hear any family law attorney tell you that it depends, and that's really true. I really like to think of it in terms of alcohol use. If you're doing it in front of the children, are you doing it responsibly? Smoking in front of kids is never a great idea because there are secondhand smoke concerns. Are you doing it after they've gone to bed? That's probably a better idea. Judges don't want to hear about you drinking or imbibing cannabis and then driving your kids around. But is it something that you're doing as after they're in activities or in bed? I do think that context is key in that case.
And Joe, before we wrap up, I want to just address a couple more things with you on sort of the criminal side. So when you are, for example, in your line of work, if you have an individual you're representing and he or she is on probation, for example, sure, and that individual has a medical card and has a prescription to use marijuana, and then all of a sudden part of their requirements for probation is to report weekly and to test, is that going to be an issue in terms of how that person's case is looked upon, mom or dad, in terms of what a judge you think may do?
So the answer is yes. From my experience, though, most people who have criminal cases and that smoke marijuana do not have medical marijuana cards. But I can answer that question in the context of other drugs that that person has been prescribed. So if a client were prescribed some sort of opioid and was required to drug test, and that drug showed up in that client's urinalysis, all that client would have to do would be to produce a valid prescription to either his or her probation officer or the judge, and that use or that positive would be excused. I have not seen any situation in which a judge has penalized a client for having some substance, some drug in his or her system that would have been illegal without a prescription, and penalizing that client if that client actually had a prescription for that drug. By and large, most judges are reasonable, and a prescription is an excuse for ingesting that substance.
And one last thing I just want to touch upon is, in the short time that we have left, is we didn't address in sort of when you're using recreational or medically, where is a person allowed to do this? I mean, can you do it in a public place? Is it in the privacy of his or her own home? What is that?
Well, I can say this, it has to be in the home. I don't know of any public place that where the public consumption of marijuana is legal. That I just don't know that exists. And in fact, in the District of Columbia, it is explicitly codified that it is illegal to consume marijuana in public. It has to be in the home. And since in Maryland, recreational use is not legal, only medicinal use is acceptable in Maryland, it would just have to be in the home.
It'd still be a crime.
Yes.
Well, thank you both very much for joining us this evening. Unfortunately, we are out of time. I'd like to thank our guests, Joseph Caleb and Emily Gelman, for taking time to discuss the emerging laws surrounding the recreational and medical use of marijuana and the impact of those cases on in custody. If you want to know more about me or either of our guests, please look us up on our respective websites. Let us know what you do think of the show and what topics you would like to see covered in future programmings by emailing us at lawschoolforthepublic@gmail.com. Please join us for future shows in our Law School for the Public series, which explores various and timely legal topics. Thank you very much.